Right now, today, a man is walking into a courtroom to be tried for a murder from September of 1996, 30 years ago. You remember where you were. Most people who followed this case do. Nobody thought this day was coming. For 30 years, it didn't. And you'd think, after 3 decades of waiting, the paperwork that finally sent this case to trial would at least tell you one thing: who shot him. It doesn't. Look at it yourself. It's public record. The charge is murder. The name of the man who fired the gun isn't on the page anywhere. And before you tell yourself that's just how these things work, hold that thought, because there's a second document that should have settled this years ago. A memoir written by the man on trial about this exact night, this exact car, this exact gun, paid for, published, read by people who wanted the truth from the one person who was actually there. He doesn't name the shooter either. 2 documents, 30 years apart, written by 2 different people for 2 completely different reasons. Neither one says the name. So somebody made a choice not to leave that detail out by accident, to leave it out on purpose. Why would you build a murder case and skip the one answer everyone's been waiting 3 decades to hear? Stay with me. Because once you understand why, you'll watch everything that happens in that courtroom this week completely differently. Before we go further, here's what's actually on the record. Nothing more. Tupac Amaru Shakur, 25 years old, shot the night of September 7th, 1996, at a red light on Flamingo Road, just off the Las Vegas Strip. He died 6 days later at the hospital after being shot 4 times and undergoing 2 operations. Here's the part that actually explains why that night happened at all, and it starts hours earlier inside the MGM Grand. Tupac and his group had just watched the Mike Tyson fight when they ran into Orlando Anderson in the lobby, a member of a rival gang connected to an earlier incident where a chain was stolen from someone in Tupac's circle. A brawl broke out, caught on the hotel's own cameras. Prosecutors allege that beating is exactly what set the rest of that night in motion. No weapon was ever recovered. No vehicle was ever recovered. That white Cadillac has never been found. 30 years later, the man on trial, Duane Keith Davis, known as Keffe D, is 63. He was arrested in September of 2023 and indicted the day before that arrest. He's charged with 1 count: murder with a deadly weapon with the intent to promote, further, or assist a criminal gang. Here's the part people get wrong constantly. Prosecutors have never said Davis pulled the trigger, not once. The lead homicide lieutenant who worked this case described Davis, in his own words at the press conference announcing the arrest, as the shot caller, the organizer, the man who got the gun into the car. One more fact worth sitting with before we go further: Davis is the only person who was inside that Cadillac who is still alive today. Every other man who was in that car with him is dead. Whatever gets said in that courtroom about who fired that gun, he is the only one left who can actually be asked. Hold on to that distinction. It's going to matter more than almost anything else in this video. Let's start with the part that should genuinely surprise you, because it's the part almost nobody says out loud. No gun, no car, almost 30 years, and neither one has ever surfaced. And that's not me summarizing. That came from the investigator who worked this case himself. A retired detective told the grand jury under oath that they were never able to identify who rented that Cadillac, where it came from, or where it went. And when it comes to the weapon, he told them plainly that it has never, to this date, been recovered. Here's how close police actually got, and how far short it still fell. In July of 2023, a SWAT team moved on Davis's home outside Las Vegas at night. Officers on a bullhorn, ordering everyone out, hands up. They came out with computers, hard drives, boxes of photographs, a magazine with Tupac on the cover, a copy of Davis's own book, and ammunition, bullets. Even the people who ran that search were careful about what it actually proved. The official closest to the investigation told reporters at the time The detectives doubted any of what they recovered could draw a direct line between Davis and that drive-by shooting. That's not Davis's defense saying that. That's the people who executed the warrant. People watching this case online keep saying some version of the same thing. There's no real evidence here. No weapon connecting him. No vehicle. Just a man talking. That objection deserves a real answer, not a dismissal, because it's partly right. There's no forensic link tying Davis to the gun that killed Tupac. None. And here's something that doesn't get said enough. Those bullets recovered from his home did not match the shell casings pulled from the actual crime scene. So if you're waiting for a smoking gun, literally it isn't there. That objection is partially verified. The physical evidence gap is real, and it's not a small one. But no gun, no car doesn't mean no case. It means a different kind of case, one built on something else entirely. And that's where this gets uncomfortable, because what it's built on is him.
Did you have anything to do with the murder of Tupac Shakur?
No, ma'am. No, ma'am. I wasn't even in the matter. I wasn't in the matter, period.
That's Davis, days before trial, telling a reporter he wasn't even in Las Vegas that night. Now, here's the problem with that. He said the opposite for almost 20 years, not once. Not in one interview he later walked back. Over and over across nearly 2 decades, in a 2018 docuseries, in an on-camera interview in 2019, and in the 2019 memoir he co-wrote and got paid to publish, Davis described being there. In the 2008 interview specifically, the one law enforcement recorded, he described pulling up next to Tupac's car and said Anderson, quote, "popped them." In the memoir, he places himself in the front seat of that Cadillac when the shooting happened. Now he says he wasn't in Vegas at all. 2 completely different stories from the same man about the same night, separated by almost 2 decades of him telling it the other way. And here's the part that should stop you. A jury is going to hear the earlier version because back in July, a judge ruled that 2008 interview can be used at trial. Here's context that actually matters here. That 2008 interview didn't happen in isolation. Davis gave it as part of a proffer arrangement with a joint federal task force out of Los Angeles, one that was investigating an entirely different killing. The murder of Christopher Wallace, Biggie Smalls. Davis has said he believed that arrangement meant nothing he said could ever be used against him in Tupac's case either. Davis's own defense tried to keep the interview out on exactly that basis. He's actually written in his own words why he thinks it shouldn't count against him. He said he only talked because he'd been promised, quote, he would not be prosecuted. That the deal he made back then was supposed to protect him. A judge looked at that argument and disagreed. The interview is going in front of the jury anyway. There's a line from that period worth sitting with for a second because it doesn't fit the version of Davis you usually see in interviews. In his own book, talking about that decision to cooperate back in 2008, he wrote that it kills him on the inside to know he told them anything at all. He's not wrong about the gun and the car. We already told you that. But listen to what he said in that same conversation about why he ever started talking in the first place.
Do you regret the book and the interview?
Yeah, I was just after the money, and they said I was covered. I did it for the money. You know what I'm saying?
He's admitted flatly that he kept doing interviews, kept promoting that book because it paid. And that's the second objection people keep raising. He only said any of this for a paycheck. Why would you believe a word of it? Fair question. Here's the honest answer. Being paid to talk doesn't automatically make something false. It makes it something you have to weigh carefully. A financial motive can shape why someone talks. It doesn't by itself prove what they said was a lie. That objection is partially verified too. His motive is documented, he said it himself, on camera. Whether that motive makes his account untrue is a separate question, and it's one the evidence doesn't settle either way. There's a wrinkle in that memoir worth knowing too. It was co-written, and Davis himself has since disputed how much of it he actually wrote versus what his co-author put together from their conversations. That doesn't erase what's in the book. It does mean the exact line between his own words and someone else's phrasing isn't as clean as either side would like. And whatever you think of why he wrote it, a prosecutor in this case has said, on the record, exactly how much that book actually matters. He put it plainly. Had Davis never opened his mouth, never written that book, he probably would not have been prosecuted for this crime at all. Think about what that actually means. The state isn't hiding the fact that its case depends on Davis's own choice to keep talking. It's saying so directly in open court. Davis's own attorneys have pushed back on this exact point in exactly the language you'd expect. One of his lawyers told the court, there's no gun, no car, no living witnesses, nothing beyond speculation and secondhand accounts tied together 30 years later. That's not an internet comment. That's an officer of the court making that argument formally on the record. There's a third objection worth putting directly in front of you because it's everywhere in the comments on this case. Some version of, this took 30 years, so it must be weak. A rushed case. A publicity stunt dressed up as justice. Here's what actually happened. Nevada doesn't put a time limit on prosecuting a homicide. There's no clock that ran out and forced anyone's hand. What changed wasn't the law, it was Davis. He kept talking in public for years about a case nobody had ever charged him in. Eventually, that's what got a grand jury's attention. That objection is not supported. The delay wasn't the state sitting on its hands. It was, in large part, the direct result of the man now on trial refusing to stop talking about it. The sheriff who announced this arrest said it himself, standing at that podium. For 27 years, this family had been waiting for justice, and the department knew it. Now here's where this gets genuinely strange. If you've followed this case for any length of time, you probably think you already know who pulled the trigger. A huge number of people watching this are convinced it was Orlando Anderson, Davis's own nephew. That belief didn't come from nowhere. Davis himself named Anderson back in that 2008 interview. It's the version that circulated for decades. Here's the problem. A different account exists. Testimony given directly to the grand jury from a man who said Anderson didn't actually have a clear shot from where he was sitting that night. That another man in the back seat, DeAndre Smith, spoke up, said something close to, he's on my side, I'll do it, and took the gun instead. So now you've got a second group of people, just as convinced, naming a completely different man. Both of those are held as unconfirmed, not because the testimony isn't real. It is. It's sitting in the case record right now. But because testimony naming someone isn't the same as a fact a court has actually established. Nobody has proven in any legal sense which one of them fired that gun. Anderson died in 1998. Smith died in 2004. Neither man is alive to answer for any of it. There's a third name that shows up constantly in this conversation too, and it deserves one honest sentence before we move on. Davis's own defense has argued, without offering supporting evidence, that a death row record security employee named Reggie Wright Jr. was actually responsible. Wright has directly and publicly denied any involvement. Nothing in the record supports that theory. It's not verified. It's not going anywhere in this video. Two dead men whose names are actually in the record, two competing accounts from two different points in this case's history, and a charging document that, you already know this by now, never picks a side.
I find that as admissible under NRS 51.035 subsection 3. It's clear that Mr. Davis adopted the statements therein as his own through publication, promotion, and subsequent ratification. In his interview to Vlad TV, he promotes this book as his book. He encourages people to buy it to get the real truth and not from the law enforcement or industry people. He also repeatedly says it's something like the whole truth of the situation. So he's indicated to a reporter also on 10/21/23 that he wrote the book to let people know his truth. He's adopted its contents under NRS 51.035 subsection 3B. And then ultimately, when you look at the entirety of Mr. Shaw's interview, it supports that the factual content from the book was from Mr. Davis, and that Mr. Davis ultimately also got the manuscript and made no edits to the description of the murder that's relevant for today. Ultimately, the arguments regarding what Mr. Jaw's contributions to the book are, etc., goes to weight, not admissibility of the book. I really find there is no legal argument to exclude the book. When I look at the PSAMA factors that have been laid out, I don't think they apply here necessarily to establish involuntariness, really. I don't find it that it's involuntary either. However, I do have problems with that 2008 interview, but I don't think that they were necessarily addressed in the framework that I'm given here. So I'm not necessarily saying it's admissible. I'm saying it's not voluntary at this time. So the motion is denied as written.
That's not a side story either. That's a judge on the record in open court ruling that Davis's own recorded words, the ones where he names Anderson directly, are going in front of that jury exactly as he said them. So here's what actually survives once you strip away the guesswork. The state has Davis's own decades of statements. It has grand jury testimony pointing one way. It has Davis's own account pointing another way entirely. What it does not have anywhere in any document is a name it's willing to put down as settled fact. And that state isn't relying on Davis's words alone to make this case land in front of a jury. The witness list released ahead of this trial is long, and some of the names on it should genuinely surprise you. Marion Suge Knight, who was driving the car Tupac died in, is on that list. Nevada's sitting governor, who ran the police department that made this arrest before he held that office, is on it too. So is a former Las Vegas mayor. Sit with the Suge Knight name for a second, because there's a detail in it people miss. He survived that shooting. He was in the car. And right now, he isn't free to simply walk into that courtroom on his own terms. He's serving a lengthy prison sentence in California for a completely unrelated case from 2015. One of the few people who was actually there that night has spent years behind bars for something that has nothing to do with Tupac at all. Being named on a witness list doesn't mean someone actually takes the stand. Prosecutors list far more names than they end up calling, but the size and reach of that list tells you something on its own. This isn't a case built in a back room. It's one the state is prepared to build in full public view in front of anyone willing to watch. There's also a stack of paperwork that landed just before this trial started, close to 4,000 pages, turned over in the weeks leading into jury selection. Some of it reportedly touches on the Biggie Wallace investigation too. The same task force, the same era, a different killing entirely. We don't know yet what's actually in those pages that matters to this specific case. Nobody outside the courtroom does. That's not a gap in this video. That's a gap in what's public right now. And it's worth being honest about the difference. Given the size of this, the court has already planned for it. This trial is expected to run for weeks, and the interest around it is high enough that the courthouse has set up a daily lottery just to manage who gets a seat inside, which brings us right back to that indictment. Here's the question worth actually answering instead of just repeating it. How do you put someone on trial for murder when the document charging him never says who fired the gun? The answer is sitting in the actual language of the indictment. Prosecutors didn't charge Davis with pulling a trigger. They charged him under a theory that he counseled, encouraged, hired, commanded, induced, or otherwise procured someone else to commit the crime. Under Nevada law, that's enough. You don't have to be the shooter to be charged with the murder itself. If prosecutors can show you organized it, armed it, and set it in motion, the law treats that the same as if you'd fired the gun yourself. Think about why a law would even work that way. If the only person who can ever be held responsible for a killing is whoever happened to be holding the gun, then anyone smart enough or careful enough to stay a step removed walks away clean every time. The person who plans it, who supplies the weapon, who sets the whole thing in motion and lets someone else carry it out, that person can be just as responsible for the outcome as the one who actually fired. That's not a technicality being used to get around a weak case. That's the actual reasoning the law is built on. There's one more version of this objection worth addressing directly, because it's a genuinely common one. Some people watching this reduce it to something simple. If you were in the car, You did it too. Doesn't matter who actually pulled the trigger. That's not quite how the law actually works, and it's worth being precise here. Instead of just agreeing with the instinct, simply being present isn't enough to convict someone of murder. What prosecutors have to prove is specific action tied to intent, that Davis obtained that weapon and got it into that car for a stated purpose. Presence alone doesn't do that legal work. What's alleged here does more than that, but it still has to be proven in front of a jury, the same as anything else. Here's my actual read on this, having gone through everything sitting on the record. The missing name in that indictment isn't a weakness in the case. It's the whole point of how the case was built. Think about it from the state's side for a second. Anderson is dead. Smith is dead. Whoever actually fired that gun almost certainly died without ever facing a courtroom for it. If prosecutors had built this entire case around proving one specific man pulled the trigger, they'd have spent 30 years chasing an answer they were never going to get in front of a witness stand, because the only men who could confirm it are gone. Instead, they built it around the one person still alive who spent almost 20 years talking about his own role in it, not what he says about somebody else. What he said over and over on the record about himself. Now, you might be thinking, that sounds convenient. If you can't prove who actually did it, just charge the man who talks the most and call it organizing. That's a fair objection, and I'm not going to pretend it isn't. But that's not actually what's alleged here. Davis isn't accused of just being present that night. He's accused of obtaining the weapon and getting it into that car for a specific stated purpose. That's a materially different legal claim than he happened to be in the vicinity. Whether prosecutors can actually prove that in front of a jury beyond a reasonable doubt is a separate question. It's the one that's going to take several weeks to answer. What isn't in question is why the indictment reads the way it does. It's not an oversight. It's a case built to survive the fact that everyone who might have answered the shooter question is already dead. So where does that actually leave things? I want to be honest about what we don't know, because that's the entire point of going through all of this. We don't know in any way the law considers proven who fired the gun that killed Tupac Shakur. That question may never be answered in a courtroom. Anderson and Smith are both gone, and neither one ever stood trial for anything connected to that night. What the evidence does show is narrower and a lot more specific. Davis's own recorded words from 2008, from his memoir, from interview after interview given over almost 20 years, are now going in front of a jury. The physical evidence is thin. There's no gun, no car, nothing forensic tying him directly to the scene, and the people who searched his home said so themselves, and the legal theory prosecutors chose doesn't require them to close that shooter question at all. Weigh it honestly both directions. In Davis's favor, no weapon, no vehicle, no independent forensic evidence placing him at that scene, and a defense that's already put those exact gaps on the record. Against him, nearly 20 years of his own statements, made freely in public, describing his role in detail, plus grand jury testimony that corroborates parts of what he's described, even where it disagrees on who fired. A jury is going to have to decide which side of that actually carries more weight. Nobody outside that jury room gets to skip to the end. That's not a loophole. It's the actual shape of the case as it exists right now. Whether it's enough, whether a jury believes decades of Davis's own statements add up to guilt beyond a reasonable doubt, isn't something any indictment, any memoir, or any video can answer for you in advance. Go back to where we started. A courtroom this week, a document that never names a shooter, a memoir written by the man on trial that doesn't either. Now you know why. Not because nobody could find the answer, because the case was never built to need one. 2 documents, 30 years apart. Neither one says the name. And now you understand exactly what that silence was for, and there's still a lot ahead that isn't settled. Whether Suge Knight actually takes that stand. What's sitting inside those 4,000 pages that only surfaced right before trial. Whether a jury believes decades of Davis's own words are enough on their own to convict him of a murder the charging document never fully describes. If you want to keep following this trial as it actually unfolds, stay subscribed. This is exactly the kind of case where the next update is going to matter. Everyone named in this video who has been charged with a crime is presumed innocent until proven guilty in a court of law. Nothing in this video should be understood as a statement of guilt. The information presented here reflects publicly available court records and reporting current as of the time of publication. Thanks for watching.